Ladies and gentlemen, thank you for braving the storm for what's bound to be a hurricane of enlightening constitutional conversation. I am Jeffrey Rosen, the president of this wonderful institution, which is the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. And today, we have the huge honor of not only a member of Congress, but one of the most thoughtful constitutionalists in the Congress. Coons is remarkable on a range of levels, and I know this because we went to law school together, and we have been talking about the Constitution for many years, and back to a long drive from Connecticut to New York, where I insisted that Americans didn't properly appreciate the French, and Chris pushed back a little bit about that, to his incredibly important contributions in the Senate on issues ranging from judicial nominations to the Iran Treaty. He's distinguished himself as one of the most thoughtful members of the US Senate. Ladies and gentlemen, I'm also thrilled to announce that I'm able to share with you our first senatorial visiting scholars at the National Constitution Center. Chris Coons of Delaware and Mike Lee of Utah have agreed together to be our first bipartisan visiting scholars, and they will contribute to enlightening the nation by discussing agreements and disagreements about the Constitution, and this conversation is the first of many. Ladies and gentlemen, please welcome Senator Chris Coons. I'm so glad to have you here. We've been hanging out, and I've been trying to get you to the NCC, and here you are at last.
Thank you, Jeff, and thanks to everybody here and everyone who's watching for braving a storm and for accommodating my changing schedule today. So I just wanted to start by saying how grateful I am for your leadership at the National Constitution Center and for the opportunity to work in a bipartisan way with my colleague on the Judiciary Committee, Senator Lee of Utah, and to find ways to engage other senators. One of the things that we are sadly lacking in the modern Senate is genuine debate over the fundamental constitutional principles that underlay our work, and I think the founders would be struck by that, by the absence of real engagement between current members of the Congress. So it's my hope that working together we can begin to redress that.
Well, it's a thrilling opportunity to do just that. Say more about the gap between the founders and today. For Madison, compromise was the essence of principled constitutionalism. There's not so much of that in the Senate today.
Not so much of that. That's a wonderful understatement, Jeffrey. Here on October 2nd, I'm pleased to announce that we didn't shut down the government this week. We sort of keep clearing the relatively low bar of keeping the government open. But what we've done is to simply extend until December 11th, the date by which we have some reckoning. This will again be a year of notable cliffs. We have an impending debt ceiling challenge. Some would say crisis, but I'll say challenge in late October, early November, probably November 5th, and we've got the current continuing resolution running out December 11th. In the 5 years in which I've served in the Senate, we have had manufactured crisis after manufactured crisis rooted in a fundamental disagreement. And one of the challenges I find is that there are now an increasing number of members elected, both to the House and Senate, who are sent there not to find a midpoint, not to compromise or agree, but to strenuously object, to resist, to shut down, to strangle, to burn some aspect of the federal enterprise. And I've occasionally, perhaps puckishly, reminded colleagues that we tried that. It was the Articles of Confederation. It didn't work out so well. And that the Constitution under which we now operate does assume a certain delegation and intention to compromise.
So what changed? Why is this?
I think this has happened slowly and then all at once. And the tenor of the current presidential debate in some ways reflects the increasing treatment of politics as some combination of a sort of sports and gladiator combat and entertainment rather than the substantive work of governing that it needs to be. A couple things have happened to attenuate the relationships between senators. A majority of us no longer live in Washington. We're not raising our families there together. The era of cheap jet travel and the expectation that our constituents will have regular access to us means that I'm not an oddity and that I leave and go home all the time. Virtually all the senators run for the exits when our last vote is called on Thursday afternoon. They jump on planes from DC National, from Reagan Airport, and go home and don't return until Monday night. So our kids aren't growing up together, and we don't have personal relationships of the type we used to first. Second, the media has become far more diffuse and polarized along ideological lines. So rather than all of us sitting down to watch one or two sort of national news broadcasts as a nation, we now, on our iPods or on our iPads, are watching whatever the latest offering is from Fox and from MSNBC, which tends to reinforce our polls further. Third, the parties are no longer the central means by which you get the resources to campaign. You can raise more money in one day by being outrageous than you can in a year by being a good sort of party stalwart. Fourth, the loss of earmarks. Now, I know that's probably not a popular transparency measure for me to say that I'm in favor of the restoration of the tool of congressionally directed appropriations. They should be transparent. They should not be for for-profit companies. They should be put through a public process. But that, too, has weakened the control of committee chairs and of the institutional process. So all of this in combination, and then, of course, on top of it, Citizens United, a decision that empowers a few super wealthy individuals or organizations to significantly influence campaigns. All of it means that you've got these forces strengthening and empowering those who play at the margins and who are shouting most loudly, and disfavors and disadvantages those who want to put in the time and to work across the aisle and to be diligent and disciplined about finding solutions, because that doesn't get you a Twitter blast, it doesn't raise you money, it doesn't get you visibility. I worry that we are at a point of corroding the very core of the institution, which, at least in the Senate, historically was built on interpersonal relationships that are the result of significant amounts of time spent getting to understand each other and each other's states and each other's interests. And where as a body, it was a much more deliberative body, and where there was genuine debate, and it was less scripted and less gladiatorial.
We are hoping with our Visiting Scholars program to model that kind of civil debate in a way that, as you said, will inspire other senators. What other reforms could help? We're not going to bring back boarding houses, and iPads are here to stay, so overturn Citizens United, bring back earmarks. What would you do to bring back comedy in the Senate?
Well, and this is the subject of some debate, but I think nonpartisan redistricting is something that in the few states that have seriously tried it, and now that there seems to be no constitutional bar to it, strikes me as one way to make progress. In a few key states where highly partisan districting has led to an allocation of the state's seats within the House in a very partisan line. Fewer and fewer seats in the House of Representatives are genuinely competitive today. Part of that's the polarization of the underlying electorate, but part of it is the work of intentional districting efforts. I happen to be from a state that only has one member of the House, so it's easy for me to announce that we ought to have citizen committees doing redistricting, because it's not as if my ox is going to be gored in this case. But I was struck during the year in which I served on the Third Circuit as a clerk. There was a case that came from Pennsylvania where it was deemed a political question, and ultimately the court stayed out of reviewing a redistricting, but the facts in the case below were shocking. I mean, it really was just a dramatic example of political gerrymandering that sort of went to the very edges of what could be considered tolerable. That's one simple solution. It's probably not the only. In fact, it's certainly not the only, but it's one that I'll suggest.
And that has to come from a state level, individual states deciding to adopt these commissions. Do you need
That's
referenda, basically, to do it, because the legislatures won't adopt them on their own?
Well, it depends on the structures within the state. I do think there's things that the federal government could do that we could legislate that would encourage that, but those are not likely to be successful. I'll frankly also suggest something that's close to my heart and that I've struggled with why we've not made more progress, and that's just to protect the right to vote itself. The Voting Rights Act was, as you know, I think dealt a significant blow in a recent Supreme Court decision that was as much a challenge to our ability to legislate as it was intended to undermine the Voting Rights Act. It really was a recognition by the court that the formula on which Title II of the Voting Rights Act of 1965 rested was decades out of date. And they simply turned to Congress and said, legislate. Do some findings of fact and update the mechanism by which you determine which jurisdictions should be subject to preclearance. And we have genuinely struggled to accomplish that. I was one of a few senators who introduced a bill to restore the Voting Rights Act, and we went for a year without any Republican co-sponsor. Lisa Murkowski, Senator of Alaska, just, I think, 2 weeks ago, joined as a co-sponsor in the Senate side, which I think was a significant step forward, because protecting voting rights has always been bipartisan. The original Voting Rights Act, passed 50 years ago, never would have passed without Republican champions. And what we've seen happen at the state and local level after a court decision that allowed decisions to move forward by local electoral governing bodies without preclearance suggests that there is an organized campaign to suppress the vote, in my view.
And your bill would change the formula for preclearance and would resurrect federal oversight of districting changes?
It would make subject to preclearance jurisdictions which engage in either what are called known practices, and there's a menu of actions which, if taken, are strongly suggestive of an intention to suppress the vote, or a series of convictions of Voting Rights Act violations. Once you have passed the threshold in a state of having a certain number of findings against the state or local jurisdictions, then you're subject to preclearance for a period of time. So this could apply to any state in the country, not just those that were subject to the Voting Rights Act of 1965. Excuse me.
Thank you for coming. I know you've had a cold and we're grateful. Other bipartisan efforts, you've done some interesting stuff on surveillance reform with Mike Lee.
Yes, my daughter came to visit me last year at one point. We were in the Senate dining room, and as we were walking by, Senator Paul called out to her, and she sort of looked at him. She follows politics fairly closely. And he said, come on over, I'd like to chat with you. And he sort of was talking to her, and he says, now, do you know your father and I have done an editorial together about a current Supreme Court case? She sort of looks at me. It was about whether or not it's appropriate for smartphones to be accessed by police officers without a warrant. And the court ultimately decided in a way that I think both Senator Paul and I had hoped it might. Senator Lee and I have also worked together on privacy protections. There is a cyber bill that should be on the floor here shortly, probably within the next week or two. And I respect the fact that on a bipartisan basis, many other senators have been working to try and secure our nation from cyber hacking, from intrusion, from piracy. And they're trying to strengthen the ability of companies to share with our national security apparatus at machine speed, at very high rates of speed, significant quantities of data in order to identify what are the threats to the system and its integrity. But I'm trying to insert into that bill additional privacy protections, and so is Senator Lee. This is a pressing issue. I mean, we have other bills that we've introduced that, frankly, are probably not going to get heard. But in the very short term, there is likely to be information sharing legislation on the floor that will offer companies liability protection in exchange for sharing with the Department of Homeland Security, and then through them the rest of the federal apparatus information from their systems. I'm very concerned that the current structure of that bill does not have sufficient privacy protections. And although I don't speak for him, it's my strong impression that Senator Lee shares some of those same concerns about privacy.
That is an inspiring effort. The warrant for cell phone searches that you called for was indeed endorsed by the Supreme Court 9-0, which was very encouraging. How much of these bipartisan efforts are shared by senators' views about what the Constitution means, and how often on the Senate floor is the Constitution part of people's debate?
Well, there's a factual predicate in your question, which is that there is debate on the floor of the Senate. Forgive me.
In the cloakroom.
We just don't debate much at all. That's one of, as I talk to more seasoned senators, Senator Leahy of Vermont is the longest serving Democrat currently in the Senate. And we've had a number of conversations in which he has shared with me that they used to literally come down to the floor an hour before a major bill came to a final vote and sit at their desks and listen to the best orders of both sides or the best and most compelling policy arguments on both sides before deciding a final vote. And that has almost never happened in my 5 years. In fact, I'll say, this may sound odd, but one of the highlights of my 5 years of service in the Senate has been an impeachment. The only impeachment we've undertaken, it was the impeachment of a judge from Louisiana. And I was unfamiliar with the way the procedure works under the Constitution. But the Senate is literally closed. And the doors are closed, no records are kept, and I can't speak as to what was said or exactly what proceeded. The outcome is public record. But what happened in the chamber during that period was that a group of senators who had been asked to serve essentially as prosecutors and another essentially as the representatives of the defense. I mean, that's sort of a coarse summary, but a whole group of senators stood up and gave their summary of the case and why they believed the vote should be for impeachment, and a group of other senators spoke against impeachment. And I got to sit there for several hours and hear dozens of senators who I didn't know personally particularly well at that point. It was very new. It was fascinating. And there are some really very good orators and legal minds in the Senate, which I otherwise would have never known. So, sorry to go off on a point here, but part of why I so value your initiative in reaching out to me and to Senator Lee is that I'm struck at how rarely we ever convene as a group on a bipartisan basis and just listen to each other, listen to each other's arguments. When I was in the majority, I'm a member of the Democratic Party, when the Democratic Party was in the majority, as the geographically most proximate freshman, I was often called upon to preside. Presiding over the Senate, I presume mistakenly, was a great honor before I got there. Once I got there, I realized it is a routine duty that requires no more strength or skill than a Little League umpire. In fact, it's not even that challenging, because there's a parliamentarian right in front of you who tells you exactly what to say, every single word, and you're not allowed to engage in any way with the proceedings. But from an anthropological point of view, it's certainly a fascinating perch because you're right there and everyone's sort of working right in front of you. I got to listen to many of my colleagues, and unlike many others who preside, I didn't simply sit there and sign letters or read memos. I would often try to pay attention. So to answer your question, a significant number of my Republican colleagues who came and spoke, particularly those more recently elected, would specifically reference the Constitution as the foundation for their challenges to the administration and to its actions. I think it is far less frequently the case that colleagues of my party come to the floor and root their arguments not in policy but in constitutional principle. But if we were pressed to debate each other more often, I think that would be the case. Because I think folks at my party often have at the very foundation of their beliefs the structure of our Constitution and its underlying assumptions as an underpinning. And as you get into arguments about things as disparate as criminal justice and privacy, or the conduct of war and who should be involved in authorizing the use of force, or what is the appropriate means of interdicting illegal aliens and their deportation, something we debated at length in the Judiciary Committee, what to do with those who are undocumented, and how a just nation treats and welcomes those who are here. All of those in some way come back to constitutional principles and to the very debates that took place just a few hundred yards from here.
One of those debates with constitutional dimensions is whether there should be religious exemptions for people who object to anti-discrimination laws. Senator Lee and others have proposed a bill called, the acronym is FADA, which I remember from the Alan Sherman thing, hello MUDA, hello FADA. So I forgot exactly what it stands for, but it would allow religiously objecting individuals.
I think it's the First Amendment Defense Act.
There we go. What do you think of that act?
First, I have not read it in detail. So, as is so often the case, everything I say should have an asterisk. My impression is, that the senator from Utah is legislating in no small part in response to the case of Kim Davis. From Kentucky, a county clerk who, following on the Supreme Court case that recognized an equal protection right to have same-sex marriages recognized throughout the country, refused to issue marriage licenses to same-sex couples presenting themselves, despite a directive from the governor of Kentucky to do so. I may be wrong, but it's my impression that that's sort of the motivating incident. I have a concern about the distinction between belief and action. And without seeing the details of it, my inclination would not be to support it, because my strong hunch is that Senator Lee is trying to carve out a sphere of action where one can refuse to execute, and I find it, now that I'm saying that, I would be surprised if he is attempting to shield government officials from any sort of retribution for refusing to do their job based on religious principles. I'd be surprised if he's going that far. But you know, there's been a great deal made of those who are florists or bakers or who have facilities for the conduct of wedding receptions, who would like to comfortably refuse to make their services available to those who are engaging in a same-sex marriage because they have religious objection to the conduct of those marriages. And to the extent that the actions people are taking, whether it's refusing to carry out their constitutional duty in executing a marriage license, or whether it's refusing accommodations in a way that's discriminatory, I don't think we should encourage or support discriminatory actions that are based on differences of belief. And this is a line that has been fought over, debated, and litigated since the very beginning of our republic. One of the things I remember well from my time in county government was that the form of the oath of office that you take in county government in my state and federally actually recognizes that there are those who swear and those who affirm based on their difference of religious belief. I don't know if you've ever noticed this. I recently went to a naturalization ceremony, and there is this very sort of convoluted language about, you know, I do swear if you swear, and I affirm if I affirm. And someone who served me very well in county government happened to be a Quaker. Quakers don't swear, both generally and specifically. I also had another person in my county cabinet who was quite a sort of atheist and refused to take an oath of office that required him to swear by anything involving a supreme being. And so it was striking to me to reflect upon the fact that those questions of how one asserts fealty or subservience or acceptance of the Constitution accepts that difference in belief, going all the way back to the founding and how we wrote out our loyalty oaths in the Constitution. So this question of religious liberty and how it translates into our actions in our community, this question of whether we carry out our duties as publicly elected officials should be impinged upon by our religious beliefs, is one that we've struggled with from the very beginning of our country. It's my hope that we will continue to uphold as broad a range of beliefs as possible, but not go further than I think we should in tolerating a range of actions.
We have a wonderful exhibit downstairs that I hope you can see if you have time before you leave. And ladies and gentlemen, if you haven't seen it, check it out, on religious liberty and the American founding. And you see there William Penn's son signing a petition asking to be able to affirm rather than swear an oath because it offended his Quaker beliefs. Is there a moderate compromise bill that would protect belief but not action?
I don't know, and that's well worth exploration. One of the things I've enjoyed about my time in the Senate, I'm a divinity school graduate. I'm a regular participant in a Wednesday morning prayer breakfast that is senators only and our chaplain, and that has participants from a fairly wide range of beliefs. I think the opportunity that has afforded me to build real friendships with Republicans in a sort of safe space of shared faithfulness has led to a number of conversations about these topics. These are topics that aren't discussed really in our nation broadly as much as they should be. And very difficult questions about morality, and our actions were raised just in the last week and two by the Pope and his visit, Pope Francis, when he visited New York, when he visited Philadelphia, and when he visited Washington. Both gave remarkable, I think, speeches, but also then followed them up with striking actions. He spoke to Congress and then served lunch to the homeless. He addressed the United Nations and then went to a school in Harlem. And he addressed the World Conference of Families, performed Mass, and then went to a prison and visited with prisoners. I mean, to me, part of the power of the Pope's visit was his actions and who he chose to spend time with and where he chose to invest his effort and engagement. But he also raised a very wide range of issues, from our stewardship of the planet to how we treat those who are immigrants to our country, to the whole question of life, from conception to the death penalty, and the very difficult issues of abortion and how they play out in our politics. And last, poverty and what we're doing to fight poverty. The question of whether we can find some moderate accommodation around the balance of religious liberty and yet be a tolerant and inclusive country is one I'm passionate about, and where I have not yet found a bill that I would put my name to, but that I think is pushing in the direction of respecting religious liberty.
I was so enthusiastic in introducing you that I didn't note that you went to Yale Divinity School as well as Yale Law School. Has your divinity school background and your faith background influenced your approach to the Constitution?
That's a great question, one to which I will struggle to give a brief answer in the time allotted, because I do want to get to the questions of our audience too. And I've said this in other settings. I recently spoke to a national gathering of those who represent different groups that are atheist or agnostic or non-believers of however one best describes that. And it was an interesting conversation. We had a great evening together. It's available online if anyone's interested. But I came out of divinity school more persuaded than ever that humility is a starting principle in the face of interpreting Scripture. And as an elected official in a secular republic, I think it is important for me to both share with the folks who choose to elect me what the values frame is that I apply to parenting and to life and to trying to be a good citizen and neighbor, yet also work hard to make sure that there is abundant space for Americans who choose to contribute to our society, not from a tradition of faith, but from a tradition of either disbelief or non-faith, and that they be as fully included and recognized and celebrated as those of us who come from a perspective of religious faith. Because that, to me, really is what our founding was about people who were seeking freedom from European structures where a particular religious faith was established and was imposed.
We promised to do a little bit of talk about Supreme Court cases past and present. We actually did homework on it, so we better not waste all the prep that we did. But let's start just a few questions about last term. Obergefell and the gay marriage decision. What do you think? Constitutionally, because here we don't ask, do you agree with the policy results, although obviously as a senator you deal with policy results, but were you persuaded by the constitutional reasoning? Was it the right time for the court to decide as it did, and what will the consequences of the decision be?
That's a fairly challenging question for me. I think it's the right policy result. I'm a co-sponsor of bills to roll back discrimination, to repeal the Defense of Marriage Act, to enshrine in our laws the protection from discrimination based on sexual orientation, comparable to other protected status under Title VII of the Civil Rights Act of 1964. But I will say that the decision, the actual legal theory underpinning the decision, was not as strong as I might have hoped. There wasn't a level of scrutiny announced, if I remember correctly. There was beautiful language. It was inspiring about the importance of commitment in marriage. But it was less a piece of rigorous legal thinking than it was a sort of assertion that this was not a field where there was a clearly defined, constitutionally permissible reason to prefer opposite gender marriages over same-sex marriages. And so in the absence of that, it was unconstitutional, it was impermissible for states to bar same-sex couples. So I was pleased with the outcome. I thought the writing was certainly moving. The dissents were certainly troubling, but there were not the strong jurisprudential underpinnings that I'd hoped for.
So I'll ask the question that our law school professors would ask. If you were writing the decision, how would it write?
I don't know that I would have a stronger, that is not a question for which I've got a good answer. I'll simply say that in reading it, I was left thinking I had hoped someone else had found their way to a very concise, strong argument that supported this.
Interesting. So you're suggesting you weren't entirely convinced that the majority was constitutionally correct?
I hesitate to reach that conclusion. I'll just say that it lacked the legal specificity for which I had hoped.
And King v. Burwell.
Fascinating.
This is the case that found the Affordable Care Act to the degree that it authorizes exchanges created by the federal government rather than a state, that those exchanges were entitled to tax breaks.
Right.
And Chief Justice Roberts revealed himself to be a purposivist, not a literalist. Was that a surprise, and what did you think of his opinion?
What was striking to me about the Chief Justice's opinion was not just that he reached that result, but also that at least 2 points, I think, in the majority opinion, he quoted Scalia back to himself in what certainly seemed to me to be an intramural scrum. Because Scalia's critique was that, words have meaning, and what was it, jiggery pokery was his particular. Scalia's dissents were particularly sharp and particularly critical, and was insisting that, with these few words you can have no other result. And yet the Chief Justice was saying, a fundamental principle of constitutional interpretation is you have to look at those words in context. Statutes have structures. In fact, he refused to give Chevron deference to the IRS in the decision, in part saying, the consequences of getting this wrong to the structure and intent of the statute are so significant that we are declaring this must have been what was meant. It was a fairly strong decision in that case, and central to the survival of the Affordable Care Act. And
let me just call for questions to be brought up right now, I think would be a good time. Did it get Congress's intent correct? Were there any Congress people who, in voting for the Affordable Care Act, intended to exclude federal tax breaks from?
From what I was able to glean, I was not a member of the Senate at the time that the Affordable Care Act was enacted, but from what I was able to glean, both from the arguments and from some other documents that were distributed to interested members, no one thought that the structure of the statute was such, this was a truly novel reading. Textually possible, but truly novel. And folks who were involved, not just in the drafting and the enactment, but in the implementation of the Affordable Care Act were stunned when this argument was first advanced. It was a very, very clever argument that I think took advantage of a draftsman's error or a mistake in one word to try and undo the entire construct.
And looking ahead to this current term, there's an extremely interesting case about one person, one vote, and we were both trying to understand exactly what the argument is of the challengers who say that the denominator for apportionment in Texas should not be the population as a whole, but the number of registered voters. What do you think of that argument, and what were the consequences?
Evanwell versus Abbott.
Evanwell, yes.
I made the comment on the way out that Texas seems to be this sort of font of constitutional jurisprudence. The housing case from the last term that upheld disparate impact analysis and this and a number of others suggests that Texas continues to be a place that generates a great deal of conflict. I struggle to understand how this argument is rooted in the Constitution, which seems to me to have clearly anticipated that apportionment would occur not based on voters but on people. It is a tragic, a difficult piece of the Constitution that it literally counts then enslaved African Americans as 3/5 of a person. But in the portion of the Constitution that is delineating how new states will be admitted, and then in other parts where it speaks to the apportionment of the legislature, it seems clear to me that women who were not able to vote at the time, that enslaved African Americans who were obviously not able to vote at the time, were counted towards the creation of political structures and towards the apportionment of the legislature. And so to suggest that somehow only those who are registered to vote are now to be counted in apportionment, I'm finding their argument somewhat elusive. Baker versus Carr, which shifted apportionment from geographic boundaries to representative, sort of one man, one vote, or one person, one vote boundaries, in combination with those constitutional pieces, I would think would make this a clear case, but 4 justices granted it cert. So there is an argument here that is currently eluding me.
We had a great podcast on this question last week. Check it out. We the People and the defenders note that Article 1, Section 2 of the Constitution bases apportionment on persons rather than eligible voters. And it would also, in the discussion, emerge that if the court agrees that the right denominator is registered voters, it would have strong partisan effects helping Republicans. Tell us more about that.
Well, that depends on the state in which we're analyzing it, but in Texas, and at least as currently configured, it would. I'll just harken back to an earlier conversation we were having about gerrymandering and its impact on the functionality of the Senate as a whole. There's been debate in other quarters, I don't think it's the origin of this case, that I've heard that sort of struck me, that districts that have prisons, large prisons, have significant populations that are not able to vote, having lost that right through being convicted of felonies. And that for purposes of the apportionment of federal benefits and federal resources, there's been some debate about whether or not they should be counted in the census. I find these questions troubling, and it seems to me that we should be trying to apportion resources and engagement in the political process based on persons, not on registered voters. Another footnote that an aide shared with me was that North Dakota does not require voter registration at all. So there is at least a mechanical challenge here. And any of us who've been involved in local politics know that the list of who is registered to vote does not always reflect who is currently resident, let alone who is currently living. The regular purge of the voter rolls of those who have long since gone to their reward is an exercise much dreaded by local county officials responsible for the maintenance of the rolls. So I think there's both constitutional and technical challenges in this particular argument.
Fascinating. Last case, you mentioned Texas as being a font of constitutional drama, and it has given us the Fisher case, where the court will decide whether the University of Texas's decision to engage in affirmative action, not only by admitting the top 10% of all high school graduates in Texas, but also by taking race into account as one of several factors for 20% of the class. In addition to that, violates the Constitution. The conventional wisdom, at least on our great podcast, seemed to be that there was a decent chance that the court, 5-4, would indeed rule against Texas. What would the consequences of that be for the future of affirmative action?
Well, I think the court has there's been a series of decisions over the last decade that have steadily eroded any constitutional foundation for race-based affirmative action. And I think the path that Texas has sought of automatically admitting the top 10% of its students, any student who is in the top 10% of their class in their high school is automatically admitted to the University of Texas, which I was unfamiliar with before reviewing these cases. It strikes me as painful but elegant in that it recognizes that the schools in Texas remain racially segregated fairly sharply, and by another means enables the guaranteed admission of a certain percentage of racially representative, high-performing students. I frankly think it is unfortunate if we continue to abandon mechanisms by which we have addressed historical inequalities in our society. But in the absence of a strong showing of a history of discrimination and its impact, I understand why legal challenges continue and are successful. My own state is one where we had federal court-ordered busing for, I think, 18 years in total. We were one of very few communities in the country that were found to have intentionally discriminated on a racial basis, and there was government action. There was actual incentives provided to white residents of Wilmington to move to the suburbs, and that was the foundation for the federal busing. It would come as no surprise, I suspect, given that I'm a Democrat, that in general, I do think racism continues to be a significant problem in our society, and one that is deserving of sustained federal action and intervention in order to achieve important and positive effects. But the legal underpinnings for race-based admission preferences have been so thoroughly eroded that, to me, I'm not sure the outcome in this case is going to be a significant one either way.
That sounds exactly right. Time for just a few questions. In a continued atmosphere of Citizens United and gerrymandering, would term limits help or hurt?
A great question, one I've debated a number of times with colleagues, although never on the Senate floor. In two states I'm familiar with where very strong term limits were adopted, in Colorado and in California, and where there's been enough time that several cycles of the legislative body have come through, I was struck at the observation of some civic leaders I know in both states that the outcome was that they have elected leaders who go from brand new to the state legislature to being, significant majority leader or a speaker in just a few years because nobody's there for very long. And that the most unexpected and unfortunate outcome was that, frankly, it's the lobbyists who become more powerful because they're the only ones who have the institutional knowledge to understand how to really get things done, how to manage the budgets or how the structures of government work. When everybody goes from their first election to out the door in 8 to 10 years, institutional memory resides really only in the career policy staff or in the lobbyists. So those are two just cautionary notes, that term limits means that everybody is sort of learning on the job and that you don't have folks with significant experience built up. And it empowers those who are on, let's just say, the sides of the legislature, not the actual folks who are elected. The best term limits are an engaged electorate. The best term limits are accountable officials who have to actually go back and answer. So to me, term limits are not a magic solution or a silver bullet, although very tempting, because there's certainly plenty of folks who I would, I think given that I've only been in the Senate 5 years, I'm very fond of the idea of term limits. Once there for decades, I think folks' enthusiasm tends to wane.
Do you think the bill on criminal justice reform coming out of Senator Grassley's committee goes far enough?
I'm very excited about the compromise bill on the committee on which I serve, the Judiciary Committee, and I'm eagerly seeking a Republican co-sponsor so that I can join. This is a recent feature of our sharply divided Congress. It's the so-called ARC rules, that if you're not one of the original architects of a piece of bipartisan legislation, you're only allowed to join as a co-sponsor if you bring a Republican with you, or a Democrat in the case of a Republican bill, which is a great feature. I was soliciting other other senators, Republicans, to join this bill just yesterday. Does it go far enough? No, it does not. There's significantly more that we can and should do in criminal justice reform. Does it make a significant contribution? Yes. Both in that it represents a broad bipartisan effort. I mean, you've got folks from John Cornyn, conservative former Attorney General of Texas, to Sheldon Whitehouse, progressive former Attorney General of Rhode Island, working together on a bill to accelerate a reduction in very long sentences for those who have participated in programs to reduce recidivism and have demonstrated through how they've conducted themselves in prison that they really pose no ongoing threat. We are spending an enormous amount of our Department of Justice budget on prisons. We imprison more people than any other country on earth by several multiples. And the sort of tough on crime movement and the mandatory minimums of the war on drugs of the 80s have accumulated to a point where they're having truly toxic impacts on a few critically affected communities. So it's a great first start. There's some important provisions in there. I am a supporter of the bill and hope soon to be a co-sponsor, but it does not go far enough.
Great. Last question. There's a Third Circuit vacancy. You sit on the Judiciary Committee. Do judicial nominations matter?
They matter deeply. I think it is an embarrassment that Judge Restrepo has been waiting for months after coming quickly through the nomination process. Look, in instances which are very rare, where there's a judge who's controversial, who doesn't enjoy the support of home state senators, or where they don't seem qualified, waiting for months and months and months could be defensible. Judge Restrepo was enthusiastically supported by both Senator Toomey and Senator Casey. That's a bipartisan pair if ever there were two. And a vacancy in the Third Circuit that has been sitting open for months and months is certainly, I think, a very real challenge to the effective administration of justice in our community and our region. If they continue at the current pace, this Republican-controlled Senate will confirm fewer judicial nominations than any Congress in 50 years. And I think that will have significant and unfortunate consequences for the administration of justice. So nominations matter. When I chaired the Judiciary Subcommittee, the Courts Subcommittee of the Judiciary Full Committee, I was very active in ensuring that we moved nominees, qualified, capable nominees, as quickly as possible. We had a significant confrontation between the parties in the last Congress over filling D.C. Circuit vacancies, which I think in the end has moved some very qualified judges onto the D.C. Circuit. But at the end of the day, the Supreme Court matters. That's frankly the whole reason we're here, is because the ongoing interpretation and application of constitutional principles through the decisional work of the Supreme Court matters deeply to the vibrancy and the character of our republic going forward. And I'm very concerned that in an environment that discourages qualified candidates from putting themselves forward because they know they face 6 months or a year and a half waiting before they can possibly take a seat on the bench, I think the pace at which nominations move matters deeply to our entire community.
There are many more excellent questions from our wonderful audience. I have a constitutional duty, which Chris understands, which is to pick up my kids, but he has generously agreed to stay for just a bit and answer your questions. So I think if you stay right here, he'd be happy to answer a bit more. Ladies and gentlemen, this is just a thrilling preview of the intelligence and quality of the constitutional debates that we're going to have with the leadership of our newest visiting scholar at the National Constitution Center. Please join me in thanking Senator Chris Coons.
Thanks, Chris. Get going. Enjoy it.
Beautiful.
Happy hurricane.
Thank you.